Hello, this is Chris Whitelaw. This is a presentation that I did for the New South Wales Business Chamber a number of weeks back, but unfortunately, due to a technical hiccup, it wasn't properly recorded. So I've decided that I would redo the webinar, if you like, using my own ScreenFlow capability on my computer and using the same slides as was used for the live webinar. So the topic is how to handle a successful commercial dispute resolution. This is a topic that should be of real interest to just about every one of the thousands of SMEs, small to medium-sized enterprises operating in Australia. Commercial disputes can cause havoc to a small business particularly, and to any business really. It comes down to how much distraction you can handle and the strength of your cash flow. But my experience in speaking now all over the country to hundreds of small businesses is that by and large the majority of them would like to know how to remove or minimize the risk of being dragged into an expensive commercial dispute through the court process via litigation. So that's what the purpose of this webinar presentation is about. So I'm your presenter, and those are my details there. I set up the Commercial Disputes Management Center a number of years ago for a very specific reason. I've now been involved in dealing with commercial disputes for the best part of 30 years, and more about that, my background and my experience, you'll find at the Commercial Disputes Management Center website. But in essence, this center was set up because I was getting pretty fed up myself at seeing what happens when too many disputes end up being litigated. I would have disputes brought to me as a barrister, which once I analyzed them, could clearly see, based on experience I now have had over many years in mediating and arbitrating disputes, that they didn't need to go down that track. And the genesis of that could be clearly seen. So it's based on that experience that I set up the center to offer a better way to help more businesses capture their disputes early and deal with them early and manage them early through a process that contains the dispute, then de-escalates it, then puts it onto a very efficient management track, leading then to what's called early pre-action, pre-litigation resolution. So here's the agenda I've set for this to basically try to illustrate to you what I wanted to say within a time frame of about 35 to 40 minutes. What's the threat that you're exposed to, and why do you need to take it seriously? What do I mean by bulletproof your business against this threat and against hefty legal fees? Dispute avoidance, prevention always is better than the cure. And more often than not, the place that permits disputes to get out of control is in your contracts. And this is where you permit persons who want to be in dispute with you to use litigation hijack. And that term means that they use litigation as a threat to pressure you to settle the dispute with them on their terms. Dispute management, the goal is, as I said, to contain, de-escalate, and manage. The reverse of that, which quickly leads to litigation, is that the dispute quickly gets aggravated, escalated, managed badly with communication breakdown. Of course, parties then run off to their respective lawyers, who then start sending out letters that are very confrontational, polarizing, aggressive, etc. And then, of course, the battle lines are drawn and the matter heads into court. Dispute resolution options. Let's talk about what they are and how do you pick the best one for you. This is where I talk about the concept of dispute triage, very, very important process that should happen as early on in a dispute as possible, and how that can make a huge difference to early resolution or heading off into court. How do you find the right expert to assist you to manage and resolve your dispute? And I guess it's much the same as anything else. How do you find the best dentist, the right orthodontist, the right doctor, the right architect, the right engineer, etc., etc. And of course, there is a process that you can adopt to help you get to the right person. Resolving disputes without loss of important commercial relationships. This is one of the vital factors in commercial disputes that maybe differentiates it from many other areas of dispute. People in business, in commerce, build their businesses based on important commercial relationships. Disputes can destroy them. And when those commercial relationships, or any of them, are busted and broken and annihilated, it can cause very long-term damage to a business that may take a long time to recover from. So from our perspective, through Commercial Disputes Management Center and our approach, it's vital that we try to safeguard those important commercial relationships. So what's the threat? Litigation happens by choice or by default. That means that if you don't do anything, if you don't take any preventative action, if you don't make changes that you can quite easily make if you get the right information to minimize the risk, then litigation will simply happen when it happens. I guess it's like that expression, if you don't, what's the word? Prepare for something properly, then you become an accident waiting to happen. And this is what you don't want to do. So I'm going to try to show you how you can avoid that. And so litigation then becomes purely a choice. And of course, in some cases, litigation is necessary. What I want to ensure through this presentation is that you make that choice wisely and fully informed, so that when you do choose to litigate, it is the right choice for reasons which I'll explain later. But in all other cases, you set up things in a way to ensure that other ways, primary ways to deal with the dispute other than litigation, are always looked at first. So what happens by default when you fail to bulletproof your business against the threat? Nasty disputes can come out of left field and cause havoc to your business. It can drain your cash flow, distract your focus away from your core business, cause damage to your reputation, stress to you and to your family, to your business associates and employees. So when looked at that way, it's easy to understand why 9 out of 10 business people will loudly say, I'd like to avoid that if at all possible. If you fail to plan, then you plan to fail. You are the accident waiting to happen. What can you do? This is what you don't want to be, the accident waiting to happen. And it's out there all the time. And believe me, and touch wood, just because it hasn't happened now doesn't mean that your turn isn't just around the corner. How can you bulletproof your business? The first area of focus is always your contracts. This is the primary source of disputes that escalate out of control, that you get exposed to persons who will up the ante on you quickly using the litigation hijack. You can avoid it, by having well-drafted contracts and maximize your protection against this threat. You can upgrade your dispute management process, introduce new policies and procedures, or revise them, upgrade them, that foster the right approach, which is early identification of an emerging dispute so that you can capture it, contain it, quickly de-escalate it, skillfully manage it, and achieve early low-cost dispute resolution, and in that process, at the same time, protect your important business relationships. Know when to request expert assistance and what expert to go to. You don't just go to anyone, just as you wouldn't go to any doctor, any dentist, or whatever. You try to get background information and a referral, and know that they have the right qualifications and experience for your particular need. So in this case, you need someone who is an expert, above all, in managing and resolving commercial disputes, and that they know how to use what I call the full ADR toolkit. ADR meaning assisted dispute resolution, meaning techniques, methods, and strategies for managing and resolving disputes other than litigation. Always make litigation your last option. Exhaust the other options first. And if you go to the right expert, he or she will know how to apply the triage, which is a way of analyzing, dissecting, stripping down, and understanding your dispute so that they can design a comprehensive blueprint to manage and resolve it early. Review and upgrade contracts. Let's talk about that. What do you do? Drafting a good contract is an art form. It requires a special skill set. I make that point because many people early on in business, to save money, will skip this as a cost saver and look around, go online, find some precedents, cut and paste, and think that they've done a great job in doing it for themselves. Now, it may save you money for the time being, and in fact, maybe the threat will never manifest. But you have to understand, if you do it that way, you are deliberately, with your eyes open, assuming a very serious risk. A good contract is drafted in plain English, and it's easy to read and understand. Any time you look at a contract and it's hard to understand, or it baffles you, or it's got all sorts of archaic language or big words or whatever, avoid it, or don't sign it until you have it fully and properly explained to you. The point I'm making here is that lawyers these days should be trained in the skill of drafting plain English, easy to read and understand contracts. Don't hide important things in fine print. You're much better off to have them highlighted so that there can be no room for misunderstandings. Important words and phrases should be properly defined in a contract, and ambiguities eliminated using special clauses in the contracts to provide specific important definitions of certain words or phrases, and interpretation clauses. People skilled in contract drafting know exactly how to do this well. Each party's duties and obligations need to be very clearly set out and stated in the contract. Again, to remove ambiguity, remove uncertainty, to make it crystal clear what these important duties and obligations are. Terms and conditions that are of fundamental importance to each of the parties to the contract need to be very clearly identified, and usually this is done through a special conditions clause so they really stand out. And what else? You can remove the threat by installing in your contracts a set of specific clauses that an appropriate expert can draft for you under the heading of dispute management, dispute resolution. Parties to a business contract can elect to manage and resolve their disputes without resort to litigation if they spell out the process and the protocol in their contract. This usually involves agreement to a stepped or progressive protocol to deal with any dispute that may arise. And the usual progression or sequence is start off with direct negotiation. If necessary, use some conciliation to remove a roadblock. Use neutral experts that both sides respect to deal with some technical expert issue that might be there. Then mediation, and you move to mediation once these technical things are resolved so they don't stand in the way of resolution of mediation. And there may be matters that come up in the course of the mediation or separate to mediation that the parties say the only way to properly deal with this is to have some appropriate expert person make a determination. Well, that's what private arbitrators do. Why go through the long, expensive, and uncertain life of a court hearing and a trial when there are people out there that have the requisite skills available to you privately that you can engage right up front and get the issue dealt with and out of the way. Commercial arbitration clauses are now extremely popular in business commercial type contracts. Doing this, litigation is either totally eliminated as an option or made the very last resort, if all else fails. Make the courts the very last resort and ensure that that is so by the way your contracts are drafted. We move into the next agenda item. Now here's something that's just passing on to you because I was made aware of this through my contacts at New South Wales Business Chamber. If you are a small business or a medium-sized business and it's important to you to conserve your cash flow and you don't have the available money to go out and pay expensive lawyers to do different types of agreements and things for you, there's a service that's available through New South Wales Business Chamber where you can get access to just about every vital type of contract or pro forma or whatever else to fully equip you with strong, vetted, that's legally vetted documents. Over 200 legally compliant HR, IR, and safety documents can be accessed through this service. They can be customized to suit your particular business needs. They can store and manage all your documents for you in one secure location, reviewed by Australian business lawyers and advisors. So it's called HR Advance. So I've kept that slide in here because I've had a look quickly at some of these and it looks to me very high quality, but you can check it out for yourself. But I'm just passing this on to you. And there's a number of packages there that you can pick from. Now, you can access all this by just going straight to the New South Wales Business Chamber and making an inquiry. So those are the details there. I want to talk about adversarial approach versus constructive and creative thinking approach. This really is what differentiates the approach that underpins litigation and the approach that underpins the alternative ways that help keep people out of court, keep you in business, doing what you really want to do, and minimizing the time that you're engaged in dispute management and resolution. It's what I call the constructive and creative thinking approach, and it is a very, very different approach. So the difference is huge, and it's vital that you understand it. So that when you make decisions that go one way or the other, you do so with your eyes open and understanding why you're making that choice. Last point there, many lawyers advertise, and you'll see it on their websites, that they offer you both these services. I'm here to tell you, based on my 30 years of experience working with both approaches, working as a litigation solicitor, as a litigation barrister, and then working as an accredited mediator and dispute resolver, that it's very hard to be a solicitor, who is usually the first port of call for entities or people who are in dispute, to properly differentiate between the two different services. And this is not meant to be critical of the legal profession. It's a very difficult issue. When clients who are hot under the collar and upset and want some quick action walk through a solicitor's door, the solicitors are very aware of the fact that they need to speak in a way that matches that emotional state. And for many people who are entrenched in a very strong emotional state, they want the lawyer to basically champion their cause and indicate that they're going to do everything to vindicate that person's view of things. If they start talking a bit wishy-washy about alternatives and, putting the let's go to court off till later, and talking about compromising and all those things, they may in fact turn around, walk out the door, and go to someone else who will speak a different way to them. So it's by no means an easy issue for those at the front line, which are generally solicitors. Now, most solicitors who are dealing with commercial disputes are trained in the art of litigation. And by and large, for most firms these days, most of their money is made through engagement in litigation on behalf of clients. So whilst their websites might say, well, we do both, point I make here to business owners, to commercial managers, is that if you want to get proper triage done, in other words, someone to properly help you strip the dispute apart and look at it properly and understand the ramifications of either approach, you need someone who can do that fearlessly and without conflict of interest. I just simply wonder whether the average litigation lawyer can actually do that for you. So my suggestion is, once you're aware of this, unless you find a lawyer and demand that you get this explained to you properly, they may not do it properly. They may not explain things properly for you to understand the ramifications of either litigating or taking some alternative approach. Hence, you may need to ensure that you go to a highly trained commercial dispute resolver. That could be a lawyer or a non-lawyer, but you need to get proper triage done for you. So let's look at what what's inherent in each of these different approaches, and hopefully then you can see it in its proper perspective. The adversarial approach, which underpins litigation, is infected with these features. And this is typical, and you'll see this in all the TV shows looking at how to dominate the opposition. It's about positional strategies. Dominance using aggression, combativeness, confrontation. The attitude that there can only be one winner. The client's position that my client's perceptions of the truth is the truth. But in fact, it's only one side of the coin, and the real truth often is not known or revealed until way down the litigation track, when you've spent a lot of money. Each side has spent a lot of money and put on their evidence, their affidavits, their documents. And even then, the real truth may not come out until you're in a court case. Now, you have to understand, when you understand this, you have to make a decision for yourself. Do you want to go to someone and just say, look, run this case for me no matter what it costs, because my side of the story is the truth? Or do you think you need to stand back and pause and say, help me in the beginning to properly see the other side of the coin, see the other party's perspective, help me get objectivity before I make the decision to litigate or not? part of this mindset is if you don't agree with me, then let's go to court and we'll have a court decide. If you don't see things my way, then you're against me, you're my enemy, you're my opponent. Remember this, litigation lawyers, if you talk to them privately or listen to their private conversations, they don't say that their game is all about the truth. Their game and their job is about acting on your instructions. So if you instruct them that XYZ or XYZ is the truth, then they take it as their instructions and they'll act on that. Now, it may take 6 months or 12 months and $50,000 of your money or more before the lawyer says, well, we can see now that when a court gets to look at this, they may not necessarily accept what you said as the truth, because we've seen a lot of other stuff now, and it's open to the court to make findings against you. Remember also that if you go off to one lawyer and the other party in dispute goes to another, they're going to tell different stories to their lawyers, and each of the lawyers is going to take that as their instructions, and that's what they're going to construct your case on. So I want to show you this in these diagrams that I've prepared so you can see it in a visual representation. This is what is inherent in what I call the litigation funnel, and this is where all the time is built into it, the delay in getting to the end of the dispute and have it finally determined, and the cost that's built into it. So this is the litigation funnel, the end point being, of course, the final hearing or the trial. So a claim is filed in court. That's how things are commenced. When someone says, I'm going to go to court, they have to file a claim, a statement of claim of some kind. That's what activates the litigation process. That can get served on the other party to the dispute, and they're given a period of time to put on a defense. And if they think that you've done something wrong or they also have a claim, they'll file a cross-claim. Now, just these two things together, already you're talking about 30 to 60 days involved here, and possibly thousands of dollars already invested into the litigation funnel. It's now being case managed in the court by a judge or a registrar of the court. You'll then come, once the what they call pleadings have been completed, the claim and the defense and the cross-claim, it's then time for lawyers to engage in something that they can have a lot of fun with and cost you a lot of money, called document discovery. Document discovery can go on for a number of months, and it can be very laborious if there's a lot of documents involved, and extremely expensive. This becomes a huge distraction on you as the business owner engaging in this process. Once the documents are out there, then people can prepare their affidavits, because the affidavits then can be prepared in the light of what they know are in the documents, and this becomes what's called evidence in chief in the court case. Each side has to put on their affidavits. You cannot adduce evidence in court unless it's first in an affidavit that the other side has been served with. Lawyers then say, well, once we've done all this, we're ready to negotiate. So you can see that when lawyers are in charge, lawyers say, we can't negotiate until we've really got as much as we can out of the other party to understand their case, meaning how strong is it, how weak is it, where are the leverage points, where can we press for advantage, etc. This is all inherent in adversarial thinking, the adversarial approach. Then, if that doesn't work, which often it doesn't, because by the time they start negotiating, so much time has gone by, so much antagonism, so many allegations of different versions of the truth, so much money has been spent, it's pretty hard now to talk about compromise, because each side is saying they want their pound of flesh and they want their legal costs back. So then they progress further towards the trial, and maybe a couple of months out from the trial, the court says, or the parties agree off their own bat, to mediate. This is what I call pit stop mediation on the way to the trial. And the way it's conducted these days in the courts is not really properly what is called, what mediation is. It's really what I call a hosted settlement discussion, a hosted settlement conference, where either a court-appointed mediator or a private mediator simply hosts a bartering process between the two sides, where they try to talk money and swap offers and try to come to a position they both can accept. And if that doesn't work, then you're off to your trial. So I represent this in this model. Each side is wanting to get 100%. They want to be the all-out winner. They're competing against each other's position. So it's a total tug of war, and there can only be one declared winner. The loser is ordered to pay everyone's costs, including their own, of course. The competitive approach has these features. Stake out an extreme position, find out all you can about the other's real position, but yield minimum about yours. Rely on tactics to get the upper hand, dictate your final offer terms, accept them or reject them. If you reject them, we go to court. Now, in contrast, this is the alternative way that we, through Commercial Dispute Management Center and through the ADR philosophy, is being offered to people in a commercial dispute, and it's a very, very different approach. First of all, they get a triage happening. And the whole point of the triage with an ADR expert is to give you objectivity about your position in a dispute and to help you understand the other side's perspective. It's also to help you understand different options available to you that don't involve litigation, and then to be able to look at those non-litigious options against the litigation alternative so that you can weigh it up properly. And the whole thing here is to help you see everything in its proper place, in a proper perspective, before you make your decision which way to go. Out of that comes a blueprint. The blueprint then steers you forward according to the options that you've selected. It involves creative thinking, cooperative approach, both sides with the help of trained persons in alternative dispute resolution, helping you generate out-of-the-box options to move forward to resolution, to the end of the dispute, taking on board commercial interests, commercial concerns, to try to find ways to bring you together, not necessarily to get you, everything that you want or to give you the optimum, but something that at the end of the day you can say, this is much better to do this in a short period of time and at less money than the litigious option. So they help you generate options and solutions, but you stay in the driver's seat. You're doing this with their expert assistance. And ultimately, it's helping you move towards agreement. So this is what I call the ADR funnel. The creative approach has these features in it. As you'll see, very, very different to the adversarial approach. And I represent this in this model. So same model as the other one, but in this case, the expert is trying to help the competing parties move away from that competitive approach to a cooperative win-win approach where there's room for either side to give way in order to achieve an early commercial outcome that both sides can endorse because they say they can live with it and it's better to the litigious method. Inherent in this is transformation, because the process that I'm telling or illustrating to you here helps people adopt an approach that is more accommodating because it tries to see the other party's point of view. By adopting this approach, you can transform your business, because if you apply this approach properly, disputes tend to be captured and dissipated and removed quickly. It can transform the whole disputes industry if it becomes widespread. It can transform a community by promoting more social cohesion and cooperation as opposed to the competitiveness and combativeness of the adversarial approach. And of course, it can transform the world. It applies constructive and creative thinking rather than adversarial thinking. It aims to identify motivating underlying issues, wants, and needs of each party in the dispute, to share information and to try to understand all viewpoints, to generate the broadest array of options for mutual gain and benefit, to choose the best combination of options or agree to trial one of them, to test one of them out, or agree to withdraw. And of course, in some cases, that's what happens, and you always have the right to go to the courts if you wish, if you feel you've made the best effort that you could to resolve the dispute without litigation. We then move into managing disputes. Effective management leads to early resolution. This business that I operate was named Commercial Disputes Management Center rather than Commercial Disputes Resolution Center because it's the way that disputes are managed that produces early resolution. It's an ally of constructive thinking, and it aims to contain and de-escalate disputes through skillful management, through the skillful management of inter-party communications. We try to move parties as quickly as possible into what I call the ADR zone. This is the zone where adversarial thinking starts to give way to constructive, creative, and collaborative thinking. Once both parties move into this ADR zone, the vast majority of commercial disputes can be resolved without the need to litigate. Smart businesses adopt and implement internal policies that help foster constructive and creative thinking as opposed to adversarial thinking. And by doing so, they reap the rewards of saved time to be devoted to your business and saved expense. Next area, experts, when and who. An important part of skillful management is knowing when to brief an expert and who to brief. There are three types of experts that may become relevant to you. Legal expertise, neutral in some particular technical area, like in a building dispute. Obviously, we're talking about neutral experts who are experts in building matters. And the dispute manager and resolver. It's very important to understand the difference between these different types of expertise, what each has to offer, and how to optimize your use of these experts during the commercial dispute management process. The first expert to call in is the expert in dispute management and resolution, for fairly obvious reasons, because they're the ones who set up the initial blueprint. And in that blueprint, there'll be provision for, if there's a need to get specific legal advice or other kinds of technical expert advice, will all be spelled out in the blueprint. Picking the wrong lawyer could be a very painful experience. Of course, this is making a bit of a pun. Hopefully most lawyers are not like this one, whose main interest is in your money rather than helping you achieve an early commercial dispute resolution. And here's another one. Funnel, web, and spider solicitors. So it's always good to have a bit of fun with some legal jokes. There is an element of truth to it, and if you've read the news over the last few years, you've known that there are a number of high-profile lawyers who ultimately were dragged before the courts themselves for inappropriate behavior. You don't want to fall into their hands. So let's talk about the commercial disputes resolver, who could be a lawyer or could be a non-lawyer. This person's highly skilled in applying ADR methods and strategies to commercial disputes. The chief aim is to resolve the dispute without the need to litigate. A secondary use, if the matter is already in the litigation arena, is to work with the parties to extricate it from that arena and thereby save them, the rest of the burdens in the litigation system and the uncertainty of outcome. They start off with the triage process that culminates in drawing up a bespoke dispute management resolution blueprint. This is the accident waiting to happen. Triage. When you have an emergency medical condition and you go to the hospital, the first person who sees you is the triage nurse. The aim of triage is to obtain the necessary facts and information to decide which expert you should see for your problem. The CDR, commercial dispute resolution expert, takes the same approach. He or she will apply a triage to your dispute to work out the best approach. The expert uses triage to help him or her design you the appropriate roadmap or blueprint for your dispute. The process involves identifying core issues, eliciting conflicting perspectives from each party to see the dispute in its proper overall context and perspective, identify the current roadblocks, what's in the way of the dispute coming to a quick end. What are the roadblocks that, if not resolved, are likely to tip you into litigation? To flush out, identify the commercial interests lying behind each party's perspective in the dispute. To consider the ADR options out of the ADR toolbox and determine which will work best for this dispute. This can involve a hybrid approach. It may be that it's not just one of the things in the toolbox, but a number of them used in combination. So what's in this toolkit? It's much, much more than just mediation. It can embrace all of these different things, either singly or in combination and sequence to help you achieve the commercial goal of early exit from the dispute and early resolution. So you see it's a whole gamut of different things that the expert can make use of and consider whether they suit your dispute and include it in your blueprint. Safeguarding relationships is paramount. Business is usually built on building up these important relationships over time, and it should be a primary objective to safeguard them. So the ADR expert will make it his or her business to find out what these relationships are, to understand them, and then take all precautions to safeguard them during the dispute management resolution process. Pursuing strict legal rights and causes of action is often at the expense of losing these important relationships. The CDR expert will help you put your potential legal rights into perspective and in proper context with your commercial interests. This is something that most litigation lawyers are not trained to do, and they won't do it. And questions? This is not a live webinar, but I'll put that up here for your questions because you can send them through to me. You can do it in a number of ways, and you'll see all the contact information again. I'd be more than happy to receive your questions. And in fact, we may send out a survey, put a survey up here as well, that you can click on a link and by doing the survey, allow us to understand your situation and what you would like to get from us, how we can help you, how we can assist you. Thank you very much. It's been a pleasure putting this together for you. and I hope that you will, after watching this webinar, do a number of things. Connect with me is the main one. And you can do that in a number of ways. You can connect with me through my email. I've given Gmail there because it goes through to all my mobile devices. You can ring me on either of those numbers. You can go to my website and you can opt in there by leaving your name and your email, and you'll get access to the free guide, which is the core 7 steps that you need to follow to deal with this risk of being drawn into litigation. You can connect with me on LinkedIn. I'm a big user of LinkedIn. I have over 1,000 connections there, and there's a lot of information that is available for anyone there who wants to connect with me, not just to me on my personal profile page, but also on the Commercial Disputes Management Center company page. So it's been a pleasure spending this time with you. I hope you will find it of benefit and value, but the real value here is what you do after watching this. Key point or message that I want to leave for you is that I'm here to help. And there is lots of information about how Commercial Disputes Management Center and myself can help you on the website. I hope you go there. I hope you will click through the pages and watch the various videos. And then at whatever time feels appropriate to you, make an appointment and come in and see me. I don't charge. I don't do these on the clock. You can come in and spend whatever time you like for me to understand your situation and what your particular wants and needs are without being charged. It's only once we work out together some particular service I can offer you and you're satisfied that it will deliver you the benefits and value you want, that we move on to a fee basis. So I hope to hear from you. Goodbye.